Namaskar. It is really nice time, nice place, nice section. Today we are explaining, defining, describing our holy Indian culture, our holy constitution, expresses, defines, describes the different changes. After all the changes, how our country, our nationalistic, patriotistic feelings give us freedom, makes us independent. It is due to the spiritual values of our nation. Throughout the world, our nation is known by its unity in diversity. Our own freedom fighters, free thinkers, forefathers, foretellers, forecasters, those who came in India, they addressed the message of humanity. Let's explain some changes that we see around the world constitutionally. Our Bolivarian constitution directs, instructs us to follow the path of unity, oneness, and equality. Let's explain the principle of equity. What are the effects of principles of equity on the judicial process? The main aim of the equity is justice with the parties or to achieve the object of justice when it cannot be done due to strictness of general law or there is no remedy in the general law or the treatment available in the general law is inadequate. No justice due to default procedure, then the equity provides treatment in such cases. Actually, the principles of equity are such universal principles which are based on justice and good conscience. Main principles of equity are as under. One is equity will not suffer a wrong to be without a remedy. The first formula or principles of the equity is that equity will not suffer a wrong to be without a remedy. The first formula or principle of the equity is that equity will not suffer a wrong to be without remedy. This formula is very important. It protects the rights of a person. If the rights of a person are violated or transgressed and there is no remedy in general law, the equity provides remedy. This principle is based on the aphorism that ubi just ibi remedium. If there had not this maxim, then probably there may not be any meaning to the rights. The inherent powers of the court under section 115 of the Code of Civil Procedure 1908 are based on this aphorism. The main object of it is to achieve the aims of justice. Jamna Jamnalal Bajaj versus Khemraj Nathulal EIR 1979, Rajasthan 179. Two is equity, follow the law. Equity always follow the law and does not go against it. Equity never acts adversely to the general law. Actually, the equity acts as a supplementary to the general law. According to Maitland, equity works as a supplementary to the general rule and not as a competitor. Origination of the equity is not for damaging the law but to fulfill it. The equity follows even minor matters of the law. The equity can interfere only in those matters where the general law is unable to provide remedy. Stories also of this view, according to him, where the general law is clear, there the court of equity is bound to accept it as the courts of law are bound. The Indian Registered Act 1890 is a good example of it, where a registration of a document is necessary under this act. There the court of equity cannot provide relief against that. He who seeks equity must do equity. The court of equity is the court of conscience. It is seen by the court of equity prior to allowing relief that the behavior of both the parties is equitable or not. It is the expectation of this principle that a person who seeks relief from the court of equity, it is necessary for him that he also must behave equitably. This formula is based on the doctrine of reciprocity. It may be cleared by an example. I institutes a suit against B for declaring a contract as void. Under this contract, A has already been received an amount of rupees 10,000 from B as an advance. The contract will be declared void only in the case if A is agreed to return the advance amount to B. It is not possible that the contract be declared as void and A will not return the amount to B. He who comes into equity must come with clean hands. This principle is based on good faith, conscience, and honesty. It is expected by this principle that a person who knocks the door of the court of equity should enter the court with good faith and pure conscience. Equity does not help such person who comes to the court with ill sense, deceit or duplicity. The court of equity will deny the claim of such person whose conduct or conscience is not fair. In the case of Sahida Khatun Biwi versus Devilal Shaw AIR 2004 Kolkata 191, it has been stated by the Kolkata High Court that relief of specific performance cannot be granted where plaintiffs has not come in court with clean hands. In this regard, the highwayman case is illustrative. In this case, two highwaymen robbed a traveler. A dispute between them with regard to distribution of robbed property. The accounts of robbed property and dispute for distribution were filed in the court. The suit was dismissed by the court, stating that the conduct of the parties was automatically illegal and unjustifiable. Delay defeats equity. This principle of the equity is based on this aphorism that vigilantibus et non dormantibus jura subjuvent means the equity helps of an alert and not of a lazy. This principle of the equity expects from the parties that they should be alert in respect of their rights and present a claim in the court without any unnecessary delay. If there is unnecessary delay in presenting the claim, then equity right of relief becomes time barred. The equity does not provide any relief in time barred matters. In the case of Smith versus Clay, it has been stated that the courts of equity have always denied to give any relief in such cases wherein a party has kept silence for a long period in respect of and respect his rights proper intentness is required for the relief. There is only one exception of this principle, sufficient cause of delay. Santosh Kumar Agnihotri versus Srimati Sundari Devi AIR 2005 NOC 23 Allahabad Abdul Ghafoor versus State of Bihar AIR 2012 SC 640 Sarandas versus Srimati Chintamani AIR 2012 Himachal Pradesh 27 Purity is equity. This principle may also stated in the manner that equity is pleased with equality, meaning by it is that the court of equity as far as possible considers the parties of suit with equal view, that is, pleased them equally. The equity does not think over the matter that if one party is getting more benefit than the other party under the strict rules of law. According to Hellsbury, here the meaning of parity is not wording parity but means to proportionate parity. A good example. It is an quotable illustration in this regard. A decree has already been brought by the lender against the debtor and surety due to death of surety, his successors made the payment of decree on the basis of doctrine of equity. It was held that the successors of surety are entitled to get that amount with interest from the original debtor. Equity looks to the intention rather than to the form. The principle is very practical principle. This principle is often being used in our daily life. This principle states that we should give attention to the intention of parties instead of the words in a pre-transaction. Actually, so many times use of suspicious and unclear words is taken place in the transaction. The parties wish something else but written down something else. Under such circumstances, no attention is given to the words of transaction, but the intention of parties is sussed out by using the principle and that is considered. Penalty is a good example of it according to Lord Hiriolo. Rule is this that where the penalty is prescribed only for the object of use of an article, there the main intention of deed is use of that article and the arrangement of penalty is considered only casual. In the case of mortgage, main right of the mortgage has relation to mortgage money. His right in the land is only in the form of surety of money. Thornborough versus Walter Thornborough versus War, 1975 in 3-1-628. Equity looks on that as done which ought to have been done. This principle has been expressed in many ways. As one is which is to be done under the equity that is considered as has been done. Two is the equity considered as has been done only to that which is proper to be done. Or three is the equity considered as has been done only to that which is proper to be done according to the conscience. In this way, meaning of the principle is that the equity considers that has been done by the person to whom the liability has been imposed to do something. According to equity jurisprudence, the equity which should be done with fair conscience considers it as has been done if there is a contract has been done in respect of sale of land, then the equity will consider its subject matter in respect of its result and consequences, as that the contract has been executed. This principle is mostly used in the cases of contract. The equity already accepts that a person who has promised to do something after taking consideration, he has fulfilled his promise and in this way has completed his liability under the contract. Equity inputs an intention to fulfill obligation. The court of equity is the court of justice and jurisdiction. It has been established with an aim to do justified and appropriate behavior with the parties. Hence it is natural that it may expect from the parties that they also do justified and appropriate behavior. This principle of equity is vested in this concept. According to this principle, when a liability has been imposed upon a person to do some work, then it is the duty of that person that he must complete that work, and when he has completed that work, then it is considered that he has fulfilled his liability. But sometimes such work is not done by the person for which a liability was imposed upon him to do that. Instead of that, he does the work more or less equal to the work imposed. Then a question arose that whether that work may be considered as fulfilling of his liability. The equity, while considering that work as justified, understands the intention of completion of the liability. Also, according to Snail, when there is a liability upon a person to do a work and he does any other work similar to that, which is like to understand is that the work has been done in order to fulfill the liability. then for that subsequent work it will be understood that it had been done with the intention of completing his liability. It can be explained by an example. A appoints B as a trustee to purchase a land and to maintain it. B had purchased the land, but before making arrangements he expired. Under this circumstance, the court of equity assumes that B had purchased the land with an intention in order to complete the liability. This is called indication by the equity of the intention of fulfillment of liability. Equity acts in personam. Action of equity has relevancy with the person. The meaning of it is that the equity enforces its orders by raising an effect on the conscience of a released person. In other words, it may be stated that the court of equity is dependent upon the body of defendant for execution of its decree. This principle of equity has been originated due to strict procedure of general law. Under the general law, the possession of a property was being forcibly handed over to that person for whom he was entitled to get. The court of equity was not doing like this. It passed the orders for transfer and in case of non-compliance, passed the orders for imprisonment for disregard of the court's order. Where the equities are equal, the first in time shall prevail. This formula is based on the principle of precedence. According to it, when there is disputed subject between the equitable interest and not included any inherent legal interest to anyone from them, then that equity will have a precedence over the second equity which was attached from the property in reference to time. It may be said also in this way that which has been created first between the two equitable mortgages that will have a procedure or will be applicable. In this reference, there is a case of CAV versus CAV 15 CSD 639. In this case, A on behalf of B mortgaged some property firstly with C and thereafter with B, here as the C accepted the mortgage by giving the value of legal estate. So he was actual purchaser and his right was first. This I was also of the opinion that if neither claimant has the legal estate, then between equitable interest, the first in time shall prevail. Where there is equal equity, the law shall prevail. One of the principles is that equity follows the law. Where the equities are similar, there are prevails. In case of Salim Krishna Mazumdar versus Malik Raghu Masiha, AIR 1989 SC 1596, it has been held also by the Supreme Court that where there is equal equity, the law shall prevail. The meaning of this principle is that where are equitable claims of two persons in respect of one subject matter and both are similar. But if a person of these two persons gets legal claim in respect of that subject matter along with the equitable claim, then his legal claim will prevail over the equitable claim. Taylor versus London and Country Bank 1901 to CHD 231. Let us mention various principles of punishment. Reformative theory of punishment is relative up to which extent in the present scenario. पापी जनों को दंड देना चाहिए समुचित सदा, वर वीर क्षत्रिय वंश का कर्तव्य है यह सर्वदा. Hindu lawgivers Manu summarized the object of punishment as punishment governs all mankind. Punishment alone preserves them. Punishment wakes while their guards are asleep. The wise considers the punishment as the perfection of justice. It is clear that the tradition of giving punishment is going on from the ancient time. Punishment is being given to the offenders in every period. It is adequately mentioned in the theology. So punishment is warranted to protect the society from mischievous and undesirable elements by deterring potential offenders, by preventing the actual offenders from committing further offences, transforming the tainted convicts into law-abiding citizens. In the case of Manohar versus Vinesh Anand AIR 2001 SC 1820, it has been stated by the Supreme Court that to punish and prosecute an offender is a social necessity. It is not in the interest of society that an offender be escaped from his liability. Also, in this case of Commissioner of Police versus Syed Hussain AIR 2006 SC 1246, it has been stated by the Supreme Court that to help the criminals and to provide an opportunity to them for escaping from judicial process is a serious misconduct. Considering the offences like rape as serious social and against the humanity, hardest punishment is recommended. State of Punjab versus Rakesh Kumar AIR 2009 SC 391 and State of Rajasthan versus Om Prakash AIR 2002 SC 2235. In this manner, the punishment has been supported in theology and judicial decisions. Now the question is that what should be the nature of punishment? What should be the quantity of punishment? What is the aim of punishment? Is there any alternate of punishment, etc.? We get replies of all these questions from the theories of punishment. Various theories of punishment are prevailing. The jurist has stated various theories of punishment from time to time, as there are four theories according to Kirchwell: theory of compensation, theory of atonement, theory of retribution, and theory of deterrent. Deterrent has further been divided into parts: resistance of criminal and resistance of society. Willoughby has also stated from theories of punishment, theory of retribution, theory of deterrent, theory of prevention, theory of reform. According to Thomas Hillgreen, there are mainly three theories of punishment: symbolic theory, retributive theory, reformative theory. McDowell stated five theories of punishment. One is theory of atonement, deterrent theory, retributive theory, reformative theory, theory of social utility. In this manner, the different theories of punishment have been mentioned. It is clear from these theories that some theories have been supported by the jurist. These theories are deterrent theories, retributive theory, preventive theory, reformative theory. Prior to detailing all these theories, it will be proper to state here that investigation of the offences is appropriate. Prior to giving punishment, it has also been said that uninvestigated criminals are an expensive luxury. Hence, prior to give punishment, the following points should be considered: the nature of offence, the circumstances under which the offence has been made, character and conduct of the criminal, etc. One is deterrent theory of punishment. It is the first theory of punishment. It is an oldest theory of punishment. The aim of this theory is to inflict various penalties on the offenders with a view to deterring them from committing crime. This theory also seeks to create a sense of fear in the mind of others with a view to keep them away from committing such crime. The aim of this theory is to be a terror to the evildoers and a warning to all others who might be tempted to imitate them. According to this theory, serious penalties are inflicted on the offenders so they may have a teaching and may not commit crime in the future. In the past, such punishments were being given. The punishments as to cut the hands in lieu of theft and to cut the penis of offender in case of rape were prevailing. As this punishment was inhuman, so it did not get support later on. The theory of deterrent punishment fails to achieve its goal. A hardened criminal becomes accustomed to the severity of the punishment, and deterrence does not always prevent him from committing a crime. To his retributive theory of punishment, it is also an older theory of punishment, as clear for the main aim of such punishment to take revenge from the offender. This punishment is given with the spirit of vengeance, according to P.K. said, penology, hold and do without thinking over the consequences. The revenge of evil with the evil is main aim of this theory. Bradley is of the view that a relation between penal law and vengeance is alike to relation between marriage and affection. According to Plato, justice is good and health of soul, whereas injustice is illness and evil whose treatment is punishment. According to Sir Walter Moberly, the main aim of the retributive theory is that the offender should get punishment for his wrongdoing. The punishment is necessary for the healthy society. Society does not like the offender. According to this theory, the wrongdoer should be given the same punishment as that will be suffered by the victim. That is, life shall go for life, eye for eye, and tooth for tooth, hand for hand, and foot for foot. The methods of this theory are found to be archaic, inhuman, and barbaric. Modern human rights philosophy condemns this cruel concept. Salmon was of the view that vengeance is not a treatment of the offense, but it is the reason of increase in offenses. But Professor Keaton and M.J. Sena have supported this system of punishment, preventive theory of punishment. According to this theory of punishment, the aim of punishment should not be a spirit of vengeance, but the offenses should be prevented. The offenders are a source of hurt or trouble for the society. They create unease and insecurity in the society. Hence the society is protected by punishing such offenders. The punishment is essential for maintaining peace and system. The Supreme Court is also of the view that to prosecute and punish the criminal is a social necessity. It is not in the interest of from his liability. Manohar Lal versus Vineshwanand, year 2001, SC 1820, to help the criminals and to provide an opportunity to them for escaping from judicial process is a serious misconduct. Commissioner of Police versus Sayyid Hussain, year 2006, SC 146. It is the punishment that keeps unsocial elements and offenders away from the society. This can be done by two manners, by giving punishment of imprisonment to the accused or by giving capital punishment to the accused. The famous jurist History was totally supporter of this theory. He was of the view that it is the object of all penal laws that application of them may not be there, meaning by it is that there should be so fear of punishment in the offenders that they may not do any offense. If they will not do any offense, then there will be no requirement of application of penal laws. The jurists Bentham, Mill, etc. have also supported this theory. They are of the view that unsocial elements and offenders are required to keep away from the society. If they have not been kept away from the society, then they will create unease and insecurity in the society. All this is only possible with the punishment, but it is to be stated by the critics that unsocial elements and offenders cannot be kept away from the society forever. They will return in the society after imprisonment and do unease to the society. Hence the punishment is not a redressal of offences. Reformative theory of punishment. It is the latest theory of punishment. The main aim of this theory is to redress offences by bringing imprisonment in offenders. To the followers of this theory, execution, solitary confinement and maintaining are relics of the past and enemies of reformation. There is no degree in the offences but increasing continuously. Actually, offenses can be restricted by making improvement in the offender. It is a human concept that a sense of atonement creates in the offenders after wrongdoing. He wished to reform, so instead so instead of giving punishment to such persons, they may be allowed an opportunity for reforming. It is an accepted fact that no person is an offender by birth. He becomes offender due to circumstances. Hence, to give an opportunity to such persons for reforming is justifiable. It is being said that hate the sin, not sinner. That is, hate the offense, not the offender. Try in the manner so that the offender and persons become to do hate with the offense. In the case of Shivraj versus State of Maharashtra 1972 CRLJ 1783 SC. This view has been revealed by Justice Krishna Iyer that the reformative form of punishment should be enforced. Existing punishment system is not favorable to the society. Sutherland Principle of Criminology, while supporting the reformative theory, has stated that it should be made applicable according to special tendency and possibility of reforms. In total, purposeful efforts are made for applicability of reformative theory of punishment under the existing just system. Various imitations of punishment have been taken in our criminal justice system as reprimand, probation, parole, rehabilitation, remuneration in lieu of work in prison, establishment of reform houses, etc. Now the provisions of open jails are also made so that the criminals, by living in open air, may become good citizens. We have discussed the principles of natural justice. What is natural justice? Principles of natural justice are the base of complete and actual justice. Confirm the statement. It is a well-established fact of the jurisprudence that the justice is not only to be done, but it should also appear. Meaning by it is that the judicial process should be of such type so that the persons may feel that actually the justice has been taken place. Many times there is justice, but it does not appear that the justice has been taken place. It happens when either there is any error related to process or the principles of natural justice are not followed. In this way, the principles of natural justice have an important place in the judicial administration. Actually, these are the principles of natural justice which provide completeness to the justice and also create faith in the general public for the justice. A just decision is meaningless without following these principles. Assumption of natural justice is universal. It is not a new concept but continuing from the ancient time. Natural law, universal law, sacred law, etc. are its synonyms. In the case of Mohinder Singh Gill versus Chief Election Commissioner, AIR 1978, SC 851, it has been stated by the Supreme Court that the ideology of natural justice is pandemic. Its abstract is good conscience. In the case of Keshav Mills versus Union of India, 1973, 1 UM, NIP 876, it has been stated by the Supreme Court that natural justice means exercising of power in fair, unbiased and reasonable manner. In the case of Maneka Gandhi versus Union of India 1979, 1 UMNIP 243, it has been propounded by the Supreme Court that natural justice is humanitarian principle where object is to establish impartiality in the law. In the case of Ridge versus Baldwin 1964 SC 40, it has been decided that natural justice is such a system which appears fair to a specific person. In the case of Hindustan Detergent Corporation versus West Bengal Small Industries Development Corporation Limited, AIR 2005, Kolkata 129, it has been held by the Kolkata High Court that the principles of natural justice should necessarily be followed by the government and its system in their activities. The importance of the principles of natural justice is clear from the above judicial decisions, and it is also clear that these principles shall necessarily be followed in the judicial decisions and judicial administration. What are the principles of natural justice? Now the question is that what the principles of natural justice are. Mainly there are two principles of natural justice. One is reasonable opportunity of hearing should be given to both parties. Russell versus Duke of Narrowcoy 1949. I All England Reports 109. No one should be made a judgment. No one should be made a judge in his own cause or be ruled against while. Indian Pawn Works, Delhi versus Chief Commissioner, Delhi, 1969, Delhi. One is to provide an opportunity of hearing. The first principle of natural justice is hear the other party or the rule of fair hearing or the rule that no one should be condemned unheard. An appropriate opportunity of hearing to be given to both parties in every case, or to provide an appropriate opportunity of hearing to all the parties prior to taking a decision or reaching to a conclusion, that is to provide an appropriate opportunity of hearing to all the parties for taking a decision or reaching to a conclusion. Any conclusion without providing an opportunity of hearing cannot be justifiable. The decision makers should try that no party has remained unheard. The principles of natural justice states that audi ultram patrum, audi ultram partum means hear the other party also. This concept stresses that convention should not be made without hearing a person. In the case of Union of India versus T.R. Verma, EIR 1957, SC 882, it had been stated by the Supreme Court that an adequate opportunity should be given to each party to submit relevant evidence on his behalf and of hearing. A justice without giving an opportunity of hearing is abrasive or meaningless. Nawab Khan versus State of Gujarat, AIR 1974, SC 1471. This principle has been confirmed at Article 311 of the Constitution. DrRK Prasad versus the State of Uttar Pradesh, AIR 1954, SC 254, and Chantman versus S versus the State of Madhya Pradesh, AIR 1951, SC 118. Avoidance of this principle has been considered as violation of right to equality guaranteed under Article 1, under Article 14 of the Constitution. Satyaveer Singh versus Union of India, AIR 1989, SC 505, and State of Maharashtra versus KS Durgal, AIR 1985, SC 119. In the case of DAV Educational Trust versus Regional Director, National Council for Teacher Education, AIR 2010, NOC 416, Madras, it has been held by the Madras High Court that withdrawal of recognition without giving an opportunity of hearing is illegal. In totality, it is concluded that an appropriate opportunity of hearing to all the parties should be given. A justice without giving an opportunity of hearing is abrasive or meaningless. Public Prosecutor versus KP Chandrasekharan, 1989, 8 STC 6. Buadash versus the State of Punjab, AIR 1965, Punjab 342. Abhay Kumar Yadav versus Srinivasam, AIR 1981, Delhi 381, UP Singh versus Board of Governors, MSCT AIR 1982, Andhra Pradesh 159, State of Jammu and Kashmir versus Wali Muhammad AIR 1972, SC 2538. In the case of PG, Institute of Medical Education and Research versus AP Vashan AIR 2003, SCW 1286, it has been propounded by the Supreme Court that promoting the employees without giving an opportunity of hearing and not hearing of each affected person is in violence of the principles of natural justice. In the case of Messrs. Star Boost Company versus State of Jharkhand AIR 2004 Jharkhand 39, cancellation of allotment without giving an opportunity of hearing has been considered by the Jharkhand High Court as the violation of principles of natural justice. In the case of Ramesh Chand Samant Ray versus the State of Odisha, AIR 2004 Odisha 37, abolition of municipality without giving an opportunity of hearing has been considered by the Odisha High Court as illegal. In the case of Keswar Singh Arora versus the State of Maharashtra, AIR 2004 NOC 94 Bombay, it has been stated by the Bombay High Court that a notice having adequate time is required to be issued for hearing. In totality, it is concluded that an appropriate opportunity of hearing to all the parties should not only be given, but such opportunity is required to be adequate and appropriate. No one should be made a judge in his own cause. The second important principle of the natural justice is no one should be made a judge in his own cause or rule against bias. That is, no person should not be a judge or play a role of judge in this in his interest or vested. It is also necessary because if a person is judged in his own matters, then it is natural that there will be a partiality with regard to himself or his interest. In such cases, creation of a sense of doing partiality by the judge or decision maker in the public is natural. Also, it is against the concept that justice should not only be done but manifestly and undoubtedly be seen to be done. Samrat versus Sussex Justices X Party McCarthy 1924 KV 259. Belief is the base of justice. If the party loses belief, then justice appears meaningless and unsuccessful. Metropolitan Properties Company Limited versus Lennon 1969 QB 577. It has also been stated in the Frank report that when a person will be judged in his own case, then there must be real likelihood of bias. There is reasonable ground for believing that the deciding factor was likely to have been biased. In the case of Mineral Development Limited versus State of Bihar AIR 1960 SC 468, it has been stated as rule of inclination and recommended to always avoid it. Personal inclination Manakial versus Premchand Singhvi AIR 1957 SC 425, AK Karipak versus Union of India AIR 1970 SC 150, Ashok Kumar Yadav versus the State of Haryana AIR 1987 SC 454, Vaidyanath Mahapatra versus the State of Odisha AIR 1989 SC 2218, Monetary Inclination Anand Malya versus State of Madras AIR 1957 Andhra Pradesh 739, GG Bhay versus Assistant Collector AIR 1965 SC 1096, Inclination related to subject matter Muralidhar versus Kadam Singh. AIR 1954 MB 111. B. Nageshwar Rao versus Andhra Pradesh State Road Transport Corporation. AIR 1959 SC 308. Partha Sarthi versus the state of Andhra Pradesh. AIR 1973 SC 2701. Departmental inclination B. Nageshwar Rao versus Andhra Pradesh State Road Transport Corporation. AIR 1959 SC 308. SC Narayan versus the state of Mysore. AIR 1960 SC 1073. Inclination related to governmental policy T. Govindraj Mudalia versus the state of Tamil Nadu. AIR 1979 SC 974 KS Rao versus state of Hyderabad. AIR 1973 Andhra Pradesh 417. The justices should keep themselves away from all these inclinations. The inclination pollutes the justice. All these matters have also been confirmed in the theology as धर्म शास्त्रानुसारे क्रोध लोभ विवर्जितः सप्राय विवाहकस्य में शुक्राण्यं पुरोहित समितमति पश्येद व्यवहारनुक्रमात्मन् पश्येत कार्याणि वादिनो शृणुयादर्श रसीच नरप्राग्य सामिचे सदाचेन शुक्र 5913. The king should seek assistance of Chief Justice Amatya Brahmin Purohits in trial. The king should follow totally the theologies. The king should neither make trial alone nor should hear the parties. The king should not have a secret conversation with the parties in privacy. These are the original principles of natural justice which save the king and justices from the trouble at the time. Doing justice on following these principles, no one can blame for the impartiality of king and justice. Impartiality of the king or justice is blamed when the king or justice is involved in attachment, malignity, greediness, fear, and hearing in privacy, etc. Pakshpat, Dhirupshe, Karyani, Chor Panchve. राग लोभ भय द्वेष वादिनोसज रहस्युति. I would like to thank all my brothers and sisters, ladies and gentlemen, students, scholar, teacher, trainer, professor, professional, officer, official, listener, learner. I would like to thank respected doctors and directors. I would like to thank all adorable ministers and managers. I would like to thank all honorable advocates, advertisers, administrators and advisors. I would like to thank the most honorable President, Mr. Modi ji. Thank you very much. Thanks a lot. Nice to see all of you. Thank you.